The dog's ears went up before anyone else in the courtroom understood why. Hollis Vance, 6 weeks into the job and still memorizing which doors locked from which side, had been told exactly one thing about courtroom etiquette involving animals: don't touch it, don't talk to it, and if anyone asks, you say, service animal, and nothing else. He had not been told what to do when an attorney in a charcoal suit stood up, looked at the dog like it had wandered in off the street, and said, loudly enough for the gallery to hear, that he found it convenient that a woman with a workplace injury claim happened to also need a dog for sympathy. The dog did not react. The woman did not either. She sat at the witness table with her hand resting flat on the animal's back, not gripping, not stroking, just resting, the way you'd rest a hand on a railing you trusted to hold you up. Her name was Renata Solis. She'd been on the stand 11 minutes, answering plain questions about a forklift accident at a packaging plant, the height of the pallet, the angle of the turn, the moment her knee had folded under her in a way it had never folded before, when the defense attorney decided the dog was more interesting than the testimony. His name was Aldous Penrose. He'd introduced himself to the jury that morning as, 31 years in this business, and I've seen every trick there is. He said it with the easy confidence of a man who believed the line still worked, and for the first 10 minutes of the morning, in this room, it apparently had. Hollis had watched 2 jurors nod along when Penrose laid out his theory of the case: soft tissue, pre-existing condition, an exaggerated injury dressed up for sympathy. It was a theory built for a jury, and a jury, Hollis had learned in 6 weeks of standing near enough to watch faces, can be talked into almost anything before lunch. Your Honor, Penrose said, I'd like the animal removed from the courtroom. It's plainly being used to generate sympathy from this jury, and I don't see why the defense should have to compete with a prop. A few people in the gallery shifted. Somebody's program rustled. Hollis felt his stomach do something complicated, somewhere between embarrassment and recognition, because he'd wondered the same thing himself, sort of, in the hour before testimony, wondered whether the dog was strictly necessary for a deposition about a knee injury, or whether it was there to make a jury feel something. Hearing someone else say it out loud, with 31 years of confidence behind it, made the thought feel less like his own private uncertainty and more like a fact somebody official had just confirmed for the whole room. Renata Solis didn't look at Penrose. She looked at the judge. Counsel, said Judge Ibarra, not raising her voice, do you have a basis for that motion beyond your impression? My impression is sufficient, Your Honor. There's Northwest documentation before this court establishing that the animal serves any function beyond. Then we'll get documentation. Judge Ibarra turned to the clerk. Has the witness submitted certification for the animal in her pretrial disclosures? The clerk checked. She had. It had been sitting in the file since the case was first scheduled, 8 months ago, untouched by anyone because nobody had needed to touch it. Filed with the rest of the exhibits, numbered, indexed, and never once opened, because nobody had thought there was a reason to ask. Penrose hadn't read it. That much was obvious from the way his jaw tightened when the clerk said the word yes, the small flicker of recalculation behind a face that had clearly not planned for this particular fork in the road. Your Honor, I'd still move to strike the witness's testimony as compromised by theatrical presentation. The dog it's a calculated visual, designed to elicit sympathy the facts alone don't support. Hollis watched Renata Solis's face while this happened. He kept waiting for something to crack, a flush, a tightened mouth, a hand going white-knuckled on the dog's fur, the thing he'd seen 100 times already in 6 weeks on people testifying about things that hurt them. It didn't come. She sat with her hand resting flat and her eyes level, and she looked, if anything, like someone waiting patiently for a kettle to finish boiling on a stove she trusted. Mildly inconvenienced by the wait. Not afraid of what was coming out of it. Mr. Penrose. Judge Ibarra's voice had cooled by exactly 1 degree, which in a courtroom is a great deal. You're asking me to strike sworn testimony based on an unverified personal theory about a federally regulated service animal, before reviewing documentation that has been sitting in your possession, in this case file, for 8 months. Do you want to revise that motion, or do you want me to rule on it as stated? There was a pause just long enough that Hollis hoped, honestly, though he couldn't have said for whom, that Penrose would take the door being held open for him. As stated, Your Honor. It was the wrong answer, and the room seemed to know it a half-second before Judge Ibarra did anything about it. A juror in the back row exhaled audibly. The court reporter's hands kept moving without missing a beat, the way Hollis had noticed they always did, like the only person in the room not surprised by anything was the one whose job was to write all of it down. "Clerk, please pull Exhibit 14 from the pretrial file." The exhibit came up on the screen mounted above the jury box. Hollis, standing close enough to read it from his post, took it in piece by piece, the seal first, blue and gold, a federal agency seal he half recognized from a poster in the break room he'd walked past every day without reading. Then the letterhead. Department of Veterans Affairs, Office of Disability Compensation. A name, Renata M. Solis. And then a date that made him do the math twice, because it didn't fit what Penrose had just implied to the jury. The certification was dated 3 years before this case had ever existed. 3 years before the forklift. Before the packaging plant. Before anyone in this room, including the woman's own attorney, had heard the name Aldous Penrose, or he had heard hers. For the record, Judge Ibarra said, "I'm going to read this into the transcript, since counsel apparently has not." She did not perform the reading. She read it the way a person reads a grocery list aloud to make sure nothing's missing, which somehow made it land harder than theater would have. This certifies that the bearer, Renata M. Solis, a veteran with a documented service-connected disability rated at 60%, has been issued a trained psychiatric and mobility service animal through the department's Assistance Animal Program. Certification number, she read the number, flat, exact, unhurried, issued and verified, with annual recertification on file through the present date. She looked up over the page. That's 8 months before the events giving rise to this lawsuit, Mr. Penrose. 3 years before today. The animal was certified before either of us had ever heard of this case. Nobody in the gallery moved. Hollis realized he'd stopped breathing somewhere in the middle of the date and started again, late, the way you do when you've been holding still without meaning to. Penrose tried once more, and this was the part Hollis would describe later, to his sister, as the part where he actually felt sorry for the guy, for about 4 seconds, before remembering he didn't have to. "Your Honor, certification or not, the optics in front of a jury are." The optics, Judge Ibarra said, cutting clean through it, are that a veteran with a documented disability brought her federally certified service animal to a federal civil proceeding, exactly as the law allows her to do, and that opposing counsel attempted to have it removed and her sworn testimony stricken on the basis of an assumption he made without reading his own case file for 8 months. "I'm not striking anything, counsel. I'm entering a finding." She did. She dictated it herself, without notes, the way a person speaks when they've already decided exactly what they're going to say before they open their mouth. The finding took 4 minutes and named things plainly, with no flourish in it at all, that the motion had been made without basis and without the diligence the court was entitled to expect of any attorney appearing before it, that the conduct would be entered into the record as a formal reprimand against Mr. Penrose, with a copy forwarded to the firm's managing partner, and that if Mr. Penrose wished to avoid a referral to the Bar Association's Office of Professional Responsibility, he would withdraw the motion himself, on the record, in open court, before the morning recess. He withdrew it. He stood to do it, very straight, the way people stand when they've decided that straightness is the only dignity left available to them, and he said the single word "withdrawn" once, clearly, into the silence the room had built around him, and sat back down. The recess bell hadn't even rung yet. The entire sequence, the motion, the document, the reading, the reprimand, the retraction, had taken less time than it would have taken Hollis to walk from the courtroom to the vending machine in the hallway and back with a soda in his hand. Renata Solis's hand never left the dog's back. Not once, through any of it. When the judge called the recess at last, she rose, and the dog rose with her in the same unhurried, practiced motion, the kind of motion that told Hollis everything Penrose's certification reading hadn't quite managed to, which was that this wasn't a prop adjusting to a script someone else had written for it. It was a partnership rehearsed across years, in places none of them in this courtroom would ever see, a hallway at 3 in the morning, maybe, or a grocery store aisle on a bad day, the kind of ordinary disaster nobody puts in a federal case file. She passed close to the bailiff's station on her way out toward the hallway doors. Hollis, without entirely deciding to, said, "Ma'am," and then didn't know what else he'd meant to say after that. She paused, turning toward him with the same level patience she'd shown the whole proceeding, as if the morning hadn't cost her anything at all. "Yes. I'm sorry," he said, which wasn't the sentence he'd planned, but turned out to be the true one once it was out of his mouth. "I didn't say anything." But I wondered the same thing he said, for a second, before the judge read it out. "I shouldn't have." She considered him for a moment, not unkindly, more the way a teacher considers an honest answer to a hard question. Most people do, she said. First time they see the harness, before they know anything else about you, that's usually the first thought that crosses. That's why I keep the paperwork close, even when nobody's asked for it in months. She glanced down at the dog, who looked back up at her with the steady, unbothered attention of an animal that had clocked in for a shift and was simply waiting to find out what came next. It's not really for the courtroom, the paperwork. It's habit. Somebody always asks, eventually. Today it just happened to be a man getting paid to ask it the worst way possible. There was no edge in how she said it. No triumph, either. It was a fact, delivered the way she might have described the weather, and then she nodded once, the smallest courtesy, and walked on through the doors with the dog at her side, out into the corridor and the ordinary noise of the rest of the building. Behind her, the gallery resumed its own ordinary noise, coughing, the shuffle of paper, somebody's phone buzzing once in a coat pocket, as if nothing unusual had happened at all, which in its own way was exactly the point of what had just happened. The room had spent 4 minutes trying to turn her composure into a performance, into something staged for a jury's benefit, and the law had spent 4 minutes calmly proving, in writing, on the record, with a federal seal and a date that predated the lawsuit by 3 years, that it never had been won. Hollis Vance stood at his post through the recess and most of the afternoon session that followed, and he kept circling back, in the idle parts of his mind a long shift leaves open, to how short 4 minutes actually was when you tried to hold it up against everything it had settled. He'd come into this job assuming the badge, the post by the door, the careful business of which handle turned which way, were the part of a courthouse that mattered most. He left the day understanding something smaller and harder to explain to his sister later that night over the phone, that the part that mattered most had turned out to be a date on a page nobody had bothered to check for 8 months, and a woman who had kept her hand steady and her voice level long enough for the rest of the room to finally catch up to a truth that had been sitting quietly in her file the entire time, waiting for someone to open it.